Hello students, I am Dr. Divyansha Kumar. The topic of our discussion today is consumer interest and unfair restrictive trade practices. It is a very interesting topic as we are all consumers and this topic is directly related to our daily lives. I hope you like this lecture. Small-time entrepreneur Ankit produced soaps under the brand name Sugandh. The soap was a decent product at a reasonable price, so the villagers began to like it. The large soap manufacturer Aroma lost business to Sugandh. The large manufacturer began charging less for its soap than Sugandh. They did not care if they had brief declines in the profits as long as Aroma fully dominated Sugandh. Ankit, on the other hand, was unable to lower the price since doing so would have resulted in a significant loss. Eventually, Aroma surpassed Sugandh, forcing Ankit to shut down his company. Eventually, the company raised the rate for Aroma soap. The villagers had no choice but to buy the costly soap. Do you consider this to be fair? Naturally, no. It's not fair to the locals or to Ankit. Unfair trade practices hurt the interest of consumers in the long run by hurting small business owners who are unable to maintain their pricing below the cost of manufacturer. Any dishonest, false or deceptive exchange practice or business deception of the goods or services that are regularly sold, that is prohibited by law or that has been deemed important by a court ruling is broadly defined as an unfair trade practice. Generally speaking, unfair trading practices can include falsely luring customers, unlawfully rejecting any transaction, unjustly interfering with competitors' businesses, and unfairly excluding competitors. In today's fiercely competitive corporate and economic environment, entrepreneurs are willing to resort to unethical trade practices in order to gain an advantage over competitors. They might gain an advantage in the short term, but in the long run, this has an impact on the company and eventually the entire sector and community. Any type of misrepresentation of the items may occur. In addition to inviting a number of torts, unfair commercial practices can cause sellers to incur unwelcome financial losses. Now, let's talk about the unfair trade practices in the Indian scenario. The primary piece of legislation in India to address unfair trade practices up until 2002 was the Monopolies and Restrictive Trade Practices Act, or the MRTP, which was passed to prohibit monopolies and restrictive trade practices. All of the Monopolies and Restrictive Trade Practices Committee's outstanding cases were transferred to the Competition Commission of India for decision making based on their current phases upon the repeal of the MRTP Act and the introduction of the Competition Act 2002. Since the Competition Act did not contain a provision addressing unfair commercial practices, this was instead addressed by the Consumer Protection Act of 1986, which previously addressed unfair trade practices. Meaning and the concept of unfair trade practices. The phrase unfair trade practice is defined in the section 247 of the Consumer Protection Act 2019. It says that producing counterfeit goods or offering inferior services, failing to send invoices or cash memos for the products or services received, refusing to accept the goods or services back or withdrawing them and failing to reimburse the payment made for them, disseminating the consumer's private information, or any practice that encourages the sale, use, supply, or provision of any good or service through the adoption of the unfair method or unfair or deceptive practice that is prohibited by statute, recognized as actionable by law, or decided by a court judgment, is referred to as unfair trade practice. Let us also look at the definition of unfair business practices in India by analyzing the laws on competition and consumer protection that were passed in response to the issue. In addition to examining the theoretical foundations and differing interpretations of consumer welfare with regard to unfair trade practices that are included in both pieces of legislation, the goal of this lecture is to highlight the situation of the UTPs in the country. The unfair trade practices or the UTPs may be categorized as false representation, that is the act of expressing in writing or orally any of the following. First, implies that the products meet a specific standard for quantity, quality, grade, composition, style or model. Next, falsely implies that the services meet a specific standard, quantity or grade. Next, falsely implies that any rebuilt, used, renovated, reconditioned or old goods are new goods. Next, falsely represents that the goods or services have performance, sponsorship, approval, characteristics, accessories, uses or benefits which they do not, or falsely implying that the supplier or the seller has an affiliation, sponsorship or approval which they do not. Next, falsely represents that any goods or services are necessary or useful. Next, makes a representation to the public claiming to be a warranty or guarantee of the goods or service. Next is offer any warranty or guarantee regarding the performance, efficacy or lifespan of the good that is not supported by an adequate or proper test. Next is promises to replace, maintain or repair the goods until they have achieved a specific result. Next, if such a promise is materially misleading or there is no reasonable prospect that such a warranty, guarantee or promise will be fulfilled. Next is providing of false or misleading information that disparages the products, services or trade of individuals. Next, materially misleading regarding the prices at which such goods and services are offered in the market. It is considered an unfair trade practice when an advertisement, whether published in a newspaper or not, offers goods or services at a discounted price, but in reality, there is no intention of keeping them away for a reasonable amount of time or duration of time. The bargain price for this purpose means the price that to anyone who views the advertisement appears to be more reasonable than that such products are typically sold for, or the price that is mentioned in a way that implies it is less than the usual price. Under the free gift offer and price cream, the following constitute unfair trade practices. giving the impression that something is being given away for free when in fact the cost is covered in full or in part by the price of the item being sold. Offering gifts, prices, or other items in addition to the goods when the true intention is something different, or awarding prizes to buyers through the holding of contests, lotteries, or games of skills, chance with the true intent of boosting sales or business. Now, let us talk about the non-compliance with prescribed standards. The term unfair trade practice describes the selling or provision of products for consumer use when the vendor is aware or reasonably suspects that the products do not adhere to the requirements established by an appropriate body with respect to the product's functionality, makeup, contents, design, construction, finishing, or packaging, all of which are necessary to avoid or reduce the risk of harm to the user. Coming to the unfair trade practices in various sectors, let's take a couple of sectors and discuss. First, pharmaceutical sector. The competition between suppliers of name brand and generic medications have never ended. Eventually, these contests would take a bad turn and give rise to several examples of unethical business practices in pharmaceutical sectors. It is often recognized that when doctors are in charge of the patient, who is the drug's ultimate user, the pharmaceutical business has a big influence on how they prescribe. It is important to distinguish between promotion and knowledge. A medical representative educating physicians about the advantage and effectiveness of new drugs may have a pre-competitive effect. Next sector is the food sector. Globally, there is growing concern over unfair trade practices as well as the quantity and quality of the products. Most people are aware of cases when chemical adulterants and additives are purposefully introduced to items during manufacturing, processing, packaging, and storage to mask subpar goods, contaminate products, or make illegal profits. Such unethical and unfair business practices are quite risky because they seriously jeopardize the health of the customers. Next sector is the insurance sector. The number of people who purchase insurance is always increasing, and many consider insurance to be a critical component of the financial services industry. The issue of unfair business practice in this industry is the growing along with the number of customers. Insurance serves as an assurance that in the event of a contingent future event, the policy holder will be able to recover losses or injuries. That obligation would not be fulfilled or would be fulfilled later due to a lack of commission. As a result, it is clear that the insurance sector depends heavily on the public's trust in the provision of the promised assurances. Companies usually strive to increase a customer's commitment after attracting them with an enticing offering. They have a number of extensive exclusion and exemption clauses that are helpful to large businesses. Next is the redressal against unfair trade practices. The Consumer Protection Act 2019. The offences and penalties listed under this act are listed as follows. First, punishment for false and misleading advertisements. A manufacturer or service provider that promotes fraudulent or misleading marketing faces up to 2 years in prison and a fine of up to 10 lakh rupees as stipulated under Section 89 of the Act. Next, punishment for manufacturing, selling or distributing products containing adulterants. Now, anybody who produces, distributes or sells goods that include adulterants is subject to penalties under Section 90 of the Consumer Protection Act of 2019 in the following situations. First is, should the contaminated product not result in any harm to the consumer, the penalty might reach up to 1 lakh rupees in fines and 6 months in jail. Next, the punishment for using an adulterant containing product will be 1 year in prison and a fine up to 3 lakh rupees if the harm caused is not severe enough to warrant hospitalization. Next, if the adulterant containing product results in an injury severe enough to inflict grave hurt, the prison sentence will be 7 years and the fine might be as much as 5 lakh rupees. Next, if the product causes a consumer's death, the sentence will be 7 years in jail with the possibility of a life sentence and a fine of at least 10 lakh rupees. Now, let's talk about the punishment for manufacturing, selling and distributing spurious products. Anybody who produces, distributes or sells counterfeit products is subject to legal action under Section 91. A noteworthy piece of legislation, the Consumer Protection Act of 2019, was introduced because it benefits consumers. The Act expands the range of consumer rights and interests that are protected. First is the unfair contracts. Section 2, sub 46 of the Act, which was added by the Act, defines an unfair contract as one that requires the customer to provide an excessive security deposit in order for the contract to be fulfilled. By the acts of inclusion of unfair contracts would allow consumers to submit complaints to these situations and rein in dishonest companies. Next is the territorial jurisdiction. The Act will help consumers seek remedy for their grievances when their rights have been violated because it allows them to file complaints regardless of where they live or work for profit. Next is the false and misleading advertisements. The Act establishes stringent penalties for acts or omissions that fall under the definition of false and misleading advertisements. Next is product liability. The Act defines the term product liability as the obligation of the seller, service provider or manufacturer to make for any harm that a defective product created or service rendered to the customer causes them. Next is the mediation and alternative dispute resolution. For a prompt and efficient resolution of consumer issues, the Act gives the consumers the option to use mediation and other alternative dispute resolution procedures. Next is the e-filing of the complaints. Additionally, the Act makes it easier to file complaints online and requests video conference hearings for the Commission, hence giving the consumers an easy way to air their complaints. Competition Act 2002. In order to encourage competition in India, the Competition Act 2002 was passed. Since competition in a market guarantees that participants are searching for the most efficient means of production, resulting in high quality services and goods at the reduced prices, the ultimate goal of competition law is to preserve consumer welfare. The Competition Act of 2002, however, does not apply to all unfair trade practices. In contrast to the previous Indian competition law, the Monopolies and Restrictive Trade Practices Act, therefore, even though the MRTP Act would have applied to many consumer issues, the new Competition Act may not always do so. Let's talk about it. The Competition Act basically prohibits, first, anti-competitive agreements, which is the behavior that reduce or obstruct market competition are considered anti-competitive. Agreements that have the potential to seriously impair Indian competition and deal with the production, supply, distribution, storage, acquisition or control of commodities or services are considered anti-competitive agreements. Next is the abuse of dominant position. When a dominant business in a market or a dominant group of businesses engaging in activities with the goal of excluding or separating a competitor or of impeding the entrance of a new competitor in the future, they are abusing their dominant position and prohibiting or drastically decreasing the competition. The Competition Commission of India is an agency of the Indian government tasked with the upholding the Competition Act of 2002 across the country and stopping any action that could harm competition in the market. It was founded on October 14, 2003. In May 2009, it reached fully functionality. Landmark cases are Horlicks Limited versus Zydus Wellness Products Limited 2020. Although Zydus promoted a television commercial trivializing the products of Horlicks Limited, both parties in this case are producers of nourishing drinks. Bengali, Tamil and English were among the languages in which the advertisement was broadcasted on the television. As a result, the Delhi High Court determined that the advertisement is insulting because it offers no hard evidence of the product's quality based on a number of rulings on deceptive advertising, disparagement and laws restricting the broadcast of advertisements on television. Now, in the Veena Khanna versus Ansal Properties and Industries Limited 2007, in this instance, the complainant made an offer to buy the respondent's apartments, which the respondent accepted in writing and promised to deliver on 1st of June 1999. Nevertheless, the apartment was not delivered because it was not built by the deadline. The other party rejected the complainant's demand for a reimbursement of the deposited money plus interest at the rate of 18% per annum due to the service inadequacy. The National Commission noted that it is not particularly challenging for the client to buy an apartment at the market price due to delay in development and possession delivery. According to the National Commission, the State Commission should order the builders to provide the complainant with the apartment as soon as it is finished, and the complainant should be fairly compensated for the building delay. The State Commission received a claim for the return amount from the complaint, but the case was left unanswered for 5 years, during which the market value of the immovable property increased significantly. The National Commission further declared that since the respondents failed to deliver possession within the allotted time, the State Commission ought to order the respondents to give the complainant possession of the apartment or any other apartment of the comparable size along with suitable compensation. Alternatively, the claimant should have received enough money back to recover current cost of a comparable sized flat in the same neighborhood. In another case of Sapient Corporation employees versus HDFC Bank Limited and ORS 2012, The Sapient Corporation Employees Provident Fund Trust lodged a consumer complaint against HDFC Bank Limited in this instance. The complaint alleged that by debiting the complainant's account, OP Bank had provided inadequate services. In this instance, the court determined that there was no service defect on the part of the OP Bank and that the complainant's complaints lacked foundation. It is impossible to classify behavior that complies with regulatory body directives as carelessness or a lack of quality service. Let us now move to the conclusion of this lecture. A revised piece of legislation known as the Consumer Protection Act of 2019 gives consumers a wide range of protections against deceptive or unfair business practices, false or misleading advertising, and other issues. In order to provide parties with an expedient and efficient means of resolving consumer disputes, the Act permits consumers to pursue alternative dispute resolution procedures and mediation. The Act's provision for e-filing of complaints and e-consumer demonstrate the legislature's progressive bent. In addition, the Act added new definitions for terms like unfair contracts, product liability, and others, expanding the protection of consumer rights and giving them authority to submit complaints when such rights are violated. Thus, the gaps in the Consumer Protection Act of 1986 are filled by the introduction of these measures. The Act's adoption was crucial because it altered the scope of nation's consumer rights protection. In the end, the Competition Act protects consumer interest by complementing consumer protection regulations. With this, we come to the end of the lecture. Thank you so much for listening and I hope you learnt. Thank you.